Okay. I think I'll be okay. I'll just proceed. Let's see, where shall I stand? Okay, so this is a little project I've been working on for the last couple of years. And I'm spending, are you getting this okay, or shall I? All right. So I've been at Harvard for the last few months working on this problem. And the best thing that I've discovered at Harvard is that I'm not reinventing the wheel. And the people in the world who are sort of at the forefront of computational law are also very interested in what I'm doing. So it's good to know that I'm not just 10 years behind. So I got into this about 2-3 years ago when I was doing a lot of legal paperwork for myself. And I was reading a huge amount of legislation that said things like this. And as a programmer, my first instinct is, this is really hard to read. What we should do is drop it into a text editor, right? And give it some proper indentation, and it wants some syntax highlighting, right? And then, we can turn the whole thing into algorithms. And that's what this code really wants to be. So as a programmer, it seems obvious to me. Maybe it wasn't so obvious to other people. But the goal of this project, I think, is to be able to say, on the left, you have some computer code. On the right, you have some code in English or in German or in some natural language. And you should be able to go between the two of these. If you update this thing, that thing should update. And in the future, if you update this thing, then that thing should update, right? And that's kind of the vision. And so 2 years down the road, we've got a small startup that's raised a little bit of funding. And we are beginning to develop the actual programming language, the stuff in green that you see. It doesn't take like 6 months to develop a programming language. It takes several years. So this is a long project. It's an open source project. And we're making decent progress towards building something like this. This is an actual program that we wrote. And soon, we'll be able to press the compile button. And it will produce a whole bunch of PDFs. So I would like to think that this is the future of contract drafting. Now, just to zoom out, I know that there's a lot of people doing things in legal tech, and the legal tech landscape in Germany alone is quite complex. And in the rest of the world, there's this huge set of different areas where people are working. There's online dispute resolution, there's case management, there's legal research, e-discovery, contract management, and document automation is more where we fit. So we're in that tiny corner down here, but we're hoping that through document automation, we'll be able to grow into some of these other domains. So why do this when there are already so many document automation tools out there? There are commercial tools like Contract Express. So who here is a lawyer or works for a law firm? Okay. And who here uses Contract Express? Anyone? Yeah, one, okay. Who here uses Exari, DocGen, to do their document generation? No? This tends to be more for in-house. What about HotDocs? Does anybody use HotDocs? This is a 20-year-old piece of software that's been around a long time. I know in Germany there's this thing called Formblitz. I think this is local. Is that right? And so this is more direct to consumers rather than law firm or in-house. There are things like Docracy, where you can download free templates, and they call themselves a sort of GitHub for contracts. And then there's things like Contract Standards, which has analyzed thousands of contracts, and they've developed standard clause libraries. So this is pretty useful, right? Because I think this is the first time we've seen open repositories of legal text in a way that's easy for end users or lawyers to use. Now, on the open source side of things, there are things like Common Accord, which helps you construct contracts from components. Docassemble does the same thing. This is written in Python. There are things like Common Form, which is very open source as well. And yet, none of these really do the job that I want done. Because if you think about where all of these document assembly programs are, they lie at the end of this spectrum. They deal with syntax, right? You have Microsoft Word. And Microsoft Word may know the paragraph numbers and it may know the cross-references, right? But it doesn't know what the contract means. And that's a problem. And so what we're trying to do is move up towards semantics. And so if you have a contract that's written in a programming language, you can have the meaning of the contract available to the computer. And that's all, that allows you to do all kinds of really interesting things down the road in pragmatics, where you could say, I'm going to compile my contract, and the compiler is going to tell me that I have a regulatory violation, or it's going to tell me that my contract violates the existing contracts, or my contract, I'll have this bigger in a minute, this contract, there's a clause that is unenforceable, right? And so being able to detect these kinds of errors used to be the job of a lawyer. You would do it in your head. But in the future, we're moving it out of your head into software. So this actually goes back to 20 years ago. Nick Szabo had the idea of smart contracts. And today when we talk about smart contracts, we often mean blockchain, Bitcoin, Ethereum, self-executing, and I would call these autonomous contracts. Because if you go back to 1997, before the invention of Bitcoin, Nick Szabo, he was just saying, let's move up that curve towards semantics and let's have machine-readable contracts, machine-understandable contracts, and some kind of formal language that allows us to deal with these contracts in a machine kind of way, right? And so if you look at the way people have said, smart cars or smart cities or smart things, right? If you take away Bitcoin and blockchain, you can still have smart contracts in a way that is faithful to this vision. And definitely Bitcoin and blockchain are smart as well, but they're smart on top of this existing idea of what a smart contract is. And this actually goes back 30 years. This is one of the earliest papers in the idea of formalization, where if you look at citizenship and nationality, are you a citizen? Well, it depends, right? It depends on, are your parents citizens? Where were you born? Have you been naturalized? Have you done all these things? And it's a huge decision tree that you can very easily represent in Prolog. And so there's been a line of research for the last 30 years on formalizing contract drafting specifically. And it gets into fairly mathematical notation, but this is useful. This is the kind of thing you want to support a proper stack. And even just very recently, 2015, computational representation of financial agreements. Financial agreements tend to be the easiest kind of contract to represent, because we're not dealing with like criminal law, litigation. We're just dealing with this kind of money turns into that kind of money, which under certain circumstances will turn into that kind of money. And nobody wants to have to do this stuff by hand, right? And the big banks do this, ISDA swaps and so on. It's all completely automated. And being able to do that is, I think, the holy grail for our project. We want to be able to say, this clause doesn't make sense, and here's why, right? And this clause conflicts with that clause. Or you've written a contract where it's possible in the future for the party to be required to do one thing and another thing at the same time, but those two things can't both be done, right? We want to be able to detect conflicts and inconsistencies. And in the past, you would have to think about this, right? The thinking would have to happen inside a fairly expensive head. And now, it can happen inside a fairly cheap machine. So that's what we're doing. Some of the other outputs, by the way, we want to be able to do scenario visualizations, because often, a client will ask you, what does this mean? How much money do I get? That's what they're asking, right? And we want to be able to answer those questions, without having to just sit down and talk it through. We want to have a website and we want to have graphs. So that's the kind of thing we want to be able to do. We want to be able to say, let's output this contract. Let's compile the contract into different languages. And that becomes useful if you're doing multilingual contracts. We'll show you if multiple pieces of paperwork need to be signed, you have to sign this one, and then you have to sign that one, and then you sign that one. These contracts should be self-managing in terms of execution sequence. And then they should also output to your enterprise software. So we could say, these are the things that the contract requires you to do. let's export that into your project management system. Let's export that into your calendar system so that you know when the deadlines are.
Was that a requirement and an optional part? Why stop there? Why not also make it the source code that can be put into a computer that
Oh yeah. So we would just add Ethereum to the language outputs, and then there would be Ethereum as well. Okay. So I think, yeah, all of these things become possible once you start climbing the curve towards semantics. All kinds of different pragmatics become possible. So definitely, yeah, self-execution would be one of the outputs. So we are planning to output to Ethereum. So this is the kind of code that we've been experimenting with. We've only been doing this for about a year, and so this is still under construction. So, but the big idea is we want to be able to go from here to there to there. So we're kind of at this stage right now. We're working on what does that language look like, how is it going to output to natural language, and then some of these things lie in the future. So the things that I've showed you are a little bit like the plastic food that the restaurants have, right? It's like eventually you'll be able to eat the food, just not yet. So this, as I was researching this, I discovered that the contracts that we were looking at, some of them had bugs. And I've been programming for 20 years. Some of these bugs reminded me of the kinds of bugs that we are familiar with in software, right? So software bugs are actually very similar to contract bugs, and therefore software and contracts must be very similar. It's like, if you shoot one person and then they die in a certain way, and you shoot another person and they die in a certain way, it's like, oh, these two people must be human in the same way. So there's actually a paper about this. It's called Precision's Counterfeit. This is a very experienced contract lawyer who then went into academia. And after he went into academia, he said, okay, let's work with my undergrad class to analyze some of these contracts that I've been using all my life. And then he said, oh my God, these contracts are full of bugs, which we've never really looked at before because we've never analyzed them before. And so he started at the end of this paper, he said, maybe there's something that the legal field can learn from the software field, because the software field has built all these tools to analyze these kinds of structures. And the legal world, it's not quite that advanced. So let me give an example. Has anybody read this particular excerpt before? This was actually quite a famous piece of code. So in the software world, we have famous bugs that we study. And in the legal world, this is a famous bug, at least in Canada, because it cost a company over $1 million. So can you spot the bug? So the bug is this, right? So obviously it's effective. The agreement will continue for 5 years, and then it renews for 5 years, right? So a very, very common structure until it gets terminated by 1 year notice, right? So what is the soonest, what is the earliest time that you can terminate? Is it after 5 years, you terminate at year 6? Or can you terminate within the first 5 years? Who thinks that we can terminate only after the first 5 years? And who thinks we can terminate before the first 5 years? Right. So, as a programmer, I'm like, you can't have a program that means two things, right, to two different people. But of course, in legal, they're called judges, and of course they mean different things. So given this comma, this is the comma, that's the problem. With that comma, then these two things get modified by that thing, right? So that termination can happen anytime. If you take out the comma, then that modifies only this thing, right? And there was a pretty large case about this. And they had to call in a legal expert to write a 43-page deposition on the meaning of commas in legal contracts, right? And the name of the guy, he was Ken Adams. Ken Adams is the expert on contract drafting. He's written a couple of books on how to draft contracts. And he says, no, it's always been a huge mess. And so a few months ago, he put out another tweet where he asked this question. He said, okay, Acme shall keep the information confidential. And then he said, here's another case, Acme shall pay the purchase price. Right? These two things, very similar. They sound very similar, right? You should always keep the information confidential, as opposed to you should pay the purchase price once, obviously, right? You only pay it once. But how do you distinguish these two cases? And so this is what made me sigh. He then said, linguists, how do you describe these verbs? And I was like, no, you're asking the wrong people, right? The people who have answers for you are the mathematicians. They're the computer scientists who have thought about this kind of thing in excruciating detail, okay? And the reason that they've thought about these things is because of chips. It's because of computer chips, hardware. A little piece of silicon, a semiconductor chip, is incredibly expensive. Not in the case that the individual chip is expensive, but once you've put 10 million chips into the field, if you find a bug, that's like the end of your company, right? So you have to get these things right the first time. And the methods that chip companies use to prove that the chips don't have bugs, that's called formal verification. And this kind of logic is used to prove that your little smartphone's chip doesn't have any bugs. And so I'm just going to give you an impressionistic view of how these things work, right? So this is where you are in time. These are different states of the world or different states of the contract. You can imagine, in this world, this happens, in that world, that happens. And they've developed an entire vocabulary for describing how states change, how you can say there's definitely going to be something that happens, there's definitely going to be something that always happens, or something will happen in one particular future, or something will happen in every possible future at least once. This is what he was looking for. This is the one-time payment, right? Or there's one thing that happens in one future, or something will happen and then something else will happen eventually, right? This is the kind of logic that we see a lot in hardware, in software, and in contracts, right? You could say, after you pay the purchase price, then we deliver the services. So it's not that hard to understand what this is trying to do, right? And they've thought through a lot of ways of describing future states. So if you can't read this, it says necessarily next, so everything happens, possibly next, or necessarily in the future, possibly in the future, globally, possibly henceforth, necessarily until, possibly until. This is the kind of formal structure that Ken Adams was looking for. But the world of computer science and the world of legal feel like they're sort of in parallel, but they very rarely connect. So I think the work that is happening here is beginning to change that. So visually, this is another way of looking at how model checking, this is called model checking, expresses these kinds of properties. You can say something will always be true until something else happens. Or in one possible future, something will be true until it happens. Or in one future, that thing will be always true. Or in every future, that thing will be true, right? And so this is what he was looking for. Acme shall keep the information confidential, as opposed to Acme shall pay the purchase price at some point. Right? Does this make sense to you? It's not that hard to understand, right? It's just from a slightly different parallel universe. And so with this kind of logic, now you can take what looks like a traditional contract and say, we're going to convert this into mathematics. And once you've converted it into mathematics, you can convert it into code. And once you have it in code, you can have the machine automatically draw flowcharts, automatically detect bugs, automatically prove that certain things will be true. And so, the reason you can do this, is because they're both really the same thing, right? Contracts and programs both are specifications for the distributed execution of business processes. Distributed means that it happens in multiple places, right? And these are business processes. So when you write programs, you're really writing a contract. When you're writing a contract, you're really writing a program. And so based on this deep similarity, I think it's possible to unify these two things. And so over the last 50 years, in the software world, who here is a programmer, software engineer, anything? Okay, so you should be familiar with some of these ideas, right? And you'll just have sort of picked them up over the course of your career. Programmers have developed this whole suite of tools to make their lives easier and make their software better and make it easier to collaborate with other programmers. And then if you look at what legal tools exist, it's basically, you've got Microsoft Word, and like the most advanced technology is track changes, right? And the languages that you use are like Latin, basically. So you know, from my point of view, like I know the history of computing, and we've seen how you build out this stack over time. And I sort of feel like I know where legal is going, just in terms of the tools that you use to draft these things, right? And so every one of these missing pieces is an opportunity. And that's what we are trying to do. As a company, we are trying to serve not the law firm, right? Because I think law firms are actually quite comfortable with what they do. They don't necessarily want to be more productive or efficient because, you know, but 2 out of 3 people, 2 out of 3 people choose not to go to a law firm, right? They try and do things on their own, and they will screw things up on their own unless somebody comes along and helps them who is not a law firm. And so for us, that's the customer, that's the client. We want to help them. And the model that we can bring is very disruptive, because instead of $600 an hour, it's just going to become like, it'll be $1 per page, and we don't care what is on the page, right? That's the kind of thing that software can say. And there are a bunch of other ways that maybe we can make money. We have really no idea. We're still exploring some of these possibilities. But I posted about this a few years ago, and there was an investor in Silicon Valley who said, Mark Andreessen said, bingo. He liked the idea, and I have a lot of respect for him, so I took that as a sign that, yes, this is worth doing. And so if you ask, so what is the vision here, right? If we build a contract providing application on the web, how is this going to affect the legal industry? So we're starting out in Singapore. Singapore is a very small country with a pretty strong legal sector, and we're starting out with startup investment agreements, because startups are the ones who really need this stuff and they have no money to pay for it, because if you're raising money, then by definition you don't have any money, right? So, so I have a soft spot for these guys. So the first thing that we're doing is going to be investment agreements in Singapore. And if that works, then we should be able to expand that to investment agreements in other jurisdictions like UK, Hong Kong. Indonesia is a big one for us. And eventually we'll get to like India, Europe, US, Canada. So this is the way we plan to expand, sort of by jurisdiction this way. And after a startup raises money, the next thing that they do is they hire people. So they come back to us and they say, can you do our employment agreement? And that's when we say, yeah, sure, we can do your employment, we can do your ESOP, we can do your NDAs. So we're going to grow that way, and we're going to grow that way. And so it's possible that in the future there will be a legalese application to do this thing in this country. And I think that should be what end users really want, right? Because often they know they want something done. They don't really have the education to know specifically, right? Even if they download a bunch of templates, they don't know how to put those templates together, right? So they need help, but they're, for whatever reason, not willing to go to the law firms to get that help. So we think we can help them. And so, I think the reason this is important, the reason and people always say, is this a robo-lawyer situation? Are you going to put all the lawyers out of a job, right? But for those of you who are lawyers, right, you know that a little robot that does this is not going to put you out of a job. Lawyers do much more than draft contracts. In fact, lawyers hate drafting contracts, am I right? Like, who here actually actively looks forward to going to the office saying, I'm going to draft some contracts today, right? No, you give it to the junior associates, and the junior associates borrow it from other junior associates. Right? Nobody wants to do this. Your time is precious, right? Not just in the obvious way. So the new billing is $1,500 an hour. There are things that only lawyers can do, right? And I come from Trump land, where, like just last week, they had to have lawyers hang out at airports and help immigrants. The ACLU just received like 47 million in donations. They just got another 20 million, and they're using that money to hire 200 lawyers, right? This is the sort of thing that I think people became lawyers to do, right? You're serving the public, you're offering access to justice, you're improving social good. You're not doing it to write contracts. So this is what lawyers should be doing. You have better things to do than contract drafting. In fact, I would argue that contract drafting, a lot of the time, a client will ask a lawyer for advice in the course of drafting a contract, and they're not really asking for legal advice, they're asking for business advice, right? And the reason they're asking the lawyer for business advice is because, they're pretty inexperienced, and the lawyer is more experienced than the client, and so the client ends up asking the lawyer for a lot of this stuff. But it's not strictly legal advice. It's not the kind of thing that only a lawyer can do. A management consultant can offer that advice, an accountant can offer that advice, a piece of software can offer that advice, and they're not violating any regulations. So that's kind of the update on what I've been up to. You're welcome to, if this is the sort of thing that you like, we have a Slack chat going. We're on Twitter. You could contact me. You can check out more of what's on the website. That's kind of the vision. And I think in a year or 2 or 3, we'll have the language up and running. It's possible that law students in law schools will be learning this language. I don't know. It's possible that end users will be using this language to develop their own contracts. And so it's sort of where, yes?
Do we have time to ask questions?
Yeah, I think we have some time for questions. Do we?
5 minutes.
Okay.
I'm sure you've been asked the question a couple of times, but how do you deal with ambiguity and opacity in legal documents? For example, the employer shall be entitled to terminate the employee's contract if he is a material breach of his obligation, material breach.
Right.
How would you code that?
Yeah, I think this is kind of a question in jurisprudence, right? Like, how far back do you want to push the conflict, the dispute? Do you want to address it up front, where you spend a lot of time negotiating the contract and you say, okay, this is how we determine this factor, this is how we determine that factor, we're going to pre-appoint a mediator to be the judge in this case, and we're going to have like a super long definition section. That's one approach. The other approach is to say, let's just shake hands and get on with it, and then we'll see you in court. Right, that's the other approach.
Exactly. I would just loop in there. The liability problem I see here too. I mean, you have consumer protection. There are general terms in the German civil code that say that certain elements of the contract may not be inappropriate.
Yeah.
It's the same thing. So if I draft a contract as a lawyer, I'm liable for the advice that I give. So if I leave this to a machine, I mean, we have about maybe 6 or 7 years education in Germany, university. So I know the cases applicable, but we are not case law based here in Germany. So we are rule based approach.
Sure.
So I look into the code and I see examples of what might be considered inappropriate by the legislator. I know some cases, and I give legal advice. That's not business advice, it's legal advice. When we come to the drafting stage of a contract. So undefined legal terms and all of this. software cannot help and will never replace a lawyer. So there
Sure.
are certain limitations. So
Yeah,
I'm
absolutely.
not a coder, I'm only a lawyer, but I see the coding thing is good if you have an if-then connection, like self-executing
My
contracts in
question
a
was
way.
more open, to be honest. Yeah, maybe you do have a method of coding it. I see your point that if you negotiate it further and think of all the different scenarios, you might come up with coding for the different scenarios. I personally believe that it's impossible to conceive of every possible real-life scenario in advance.
Yep.
But you might think differently.
So if you're paying attention to the Nobel Prize last year, the Nobel Prize in Economics was given for work that demonstrates that the idea of a complete contract is a fiction, right? And it's not a good idea. So that's right. So, well, they got a Nobel Prize for it. So their approach was to say, look, let's not try to nail down every possible future. Let's just agree that if there are areas of uncertainty and ambiguity, we agree now on how to handle that ambiguity, which is sort of the next best thing you can do. So you would say, if there is a dispute in this domain, then the decision-making rights get allocated to this party or that party or a third party. And that helps to address it. But you're right, like it is very difficult for software to know exactly what to do in the edge cases, right? If there's, and it's very hard for anyone to know what to do. That's why there are lawsuits, and that's why there are appeals, right? The very fact that an appeal system exists means that courts don't always get it right.
So do I understand you right that actually you would leave in your contract system the ambiguities, the opacity of certain words? You would just leave them in there, but you would try to focus on those things that you can actually code.
And I think, yes, and I think we could also highlight the ambiguity. And I think what humans really do, right? In contract law, there's the idea of the meeting of minds, but there's also the idea of the four corners of the agreement, which is when you don't really have a meeting of minds and the judge just doesn't really care about that, right? So if people want to do a deal and they don't really agree, then they sort of push that disagreement into the penumbra of all the ambiguities, and they just hope for the best, right? And people do this all the time, right? I mean, you got married, right? So I think what we will do is we'll just highlight the ambiguity, and we'll say these are certain paths into the future that we just haven't explored, and if you want to think more about these things and you want to go and define them some more, go ahead. And if you don't want to define them, then good luck, all right? People have happy marriages even if they don't sign a prenup. So that's okay, yeah. So,
one question. I think a great presentation is a great tool. But Switzerland was on the bottom line there. No, but I think quite a big part of our job as lawyers is also the negotiation of the contract. So you come up with the first draft, like the initial idea, and then actually the real work starts. And how do you? I see that your tool is probably going to provide a very fast and accurate template to commence negotiations. But how is the negotiation process inbuilt as well?
So one of the big differences between us and the document assembly systems is that document assembly systems will give you the template, but if you want to modify the template, then they just say, okay, here's the Word doc, back to you, good luck. And in our case, what we would like to do is say, if you negotiate based on the standard template, you can keep those negotiation points in the language itself. So it's like saying, here's the program, and I'm going to modify the program, and I'm going to add some code. And after I compile that code, I will still get a working document. So that's one of the differences between us and the document assembly systems. Now, you do have to be a little bit of a coder to do this, but I think the younger generation of lawyers who grew up learning JavaScript in school, they're not going to be afraid of doing that. And so yeah, so every deal is going to have some tweaking, and every program, you download your program and then you start configuring it to suit you. That's a little bit like tweaking the software.
But that would mean then, because you said it's as a business-to-user program, it's not aimed at law firms.
Mm-hmm.
But in order to kind of do this negotiation, the changes, you would need to have a law background at least.
Would you?
I don't know.
I don't know. So let's look at a different domain, right? Let's look at the medical domain. So if this were a room full of doctors, the doctors would all say, when a patient gets sick, they have to come and talk to a doctor, because only a doctor is going to give you the proper differential diagnosis to make sure that you just have a cold and you don't have Zika and you don't have avian flu, right? Now, in practice, what do you people do, right? You go online and you Google the symptoms and you go to WebMD, right? And you read through like diagnosis, prescription, right, prognosis, and like half the time you're like, I don't really need to see a doctor for this.
Mostly, I really need to go to the hospital.
Unless you do, right? So I think there's like sometimes you can help yourself and sometimes you can't. And so our software is for the people who can help themselves. Yeah.
Very interesting. I've used Contract Express before, so basically, for anyone that doesn't know, it's like a contract automation software where you kind of change things and then you see the effect in a Word document, just as you described. I'm just interested to know what the program that you're building would look like to a user, because you're also saying that the user wouldn't be a lawyer, and in our case, that is, Contract Express is used by a lawyer. You put in answers to questions and then it comes out. So, what would it look like on a screen? Can you kind of visually describe it?
I think on the left, there would be the program. And maybe on the sort of top left, there would be a little bit of the configuration and the parameters where you put in the names and the money and the numbers. On the left is the program, and on the right is the text. And so every time you edit the program, the text will change. And if you have trouble understanding what the program means, you could read the text and try and understand that. So we actually don't know, but that seems to be the dominant model in online software composition today. Yeah.
I also have a question regarding more or less the nature of it. We as lawyers learn that language itself, from its nature, is incomplete. So there are different ways to interpret, and we are taught how to interpret incomplete.
Yeah, that's why they invented formal languages, right? That's why, like, the mathematicians would say, yes, that's why we don't do math in English, right? We don't even do math in German. We do math in math. So we're trying to give a formal foundation where we specify what all these things mean, right? Like in every possible future, or in every possible future at least once, or every possible future until something else happens. So that is a much more formal way. And I would argue that a lot of the bugs in contracts come from the fact that, the comma could mean a lot and nobody agrees on what the comma means. Once you move it into math, there's no problem with these kinds of comma situations.
Yeah, exactly. But that was the question. If you have a language, then there is a way how to interpret it. I doubt, for example, that this case around the termination of the contract would be decided in Germany or Austria, where I come from, the same way, because the behind the
So this is,
yeah?
there is an open question here, right? Do you think at some point in the future, maybe like 200 years in the far future, a judge will look at this, right? And they can look at the thing on the left, they can look at the thing on the right. And they will look at the thing on the left and they will say, this is your intent. And I will go by your intent rather than the text. Do you think a judge would do that?
This is in a German civil code, this is a basic rule.
Right.
This is the general rule.
Okay.
It's not the written thing, it's what they wanted,
Right.
what you have to judge.
Right. So, this gets you closer to the intent. And the whole chain of communication also gets you closer to the intent. So we would look at the emails anyway. This is just the final thing that you sign. It's more ceremonial. I mean, half the people don't even read it, right? So, yeah.
But I mean, exactly this comma thing is about the intent, and because I'm a developer, right? I would say this comma is actually a vulnerability in the code. And somebody abused it. They abused it for $1 million, and they actually cheated and got away with it. A developer, it would be like maybe a web server, and then it had some vulnerability, and the developer would be able to download the database and sell it in the dark web.
Mm-hmm.
And he's going to prison. But you could just say, okay, but they designed the software, so I was able to do that, so that was their intent, so I was actually invited to download and sell this data. And why is one party being prosecuted?
Mm-hmm.
But in the legal term, they're like celebrated because they are obviously abusing something that was intended in a different way.
Yep.
So, and also maybe these errors that are prone to be there in the future, how do you stop abusing in such a system of them or exploiting?
Any suggestions?
Do you have an approach?
Well, I don't. This seems like a human problem, right? This is the question of exploits. Speaking as a startup, we will make money on this by selling toolkits that allow you to do penetration testing on your contracts. And we will sell you toolkits that say, here are the bugs we found. Would you like a revised version of the contract that has fewer bugs? So, I don't know. You know, there's plenty of situations where anybody would look at a particular case and say, that is a ridiculous case. Who are the lawyers supporting this case? But, you know, they don't lose their license.
But is there research being done on it or anything? I mean, this is
Not really.
behavioral science.
Yeah.
So, but
I can't answer that question. I don't know. Yes.
I'm surprised that you're not offering it to law firms. You know, to be able to define and find contradictions in a contract before I actually give it to the client would be something that a lawyer would like to do. I think it's not, because especially as the contract gets longer and goes through 2 or 3 iterations with the party and the counterpart, things get lost.
Yeah, yeah.
It's
Sure.
a 150-page contract. You simply
Yeah, it can't fit in your head, right?
to understand at the very end, after 2 months of negotiations, whether you really do not have any inconsistencies at all.
Yeah.
If you could do that mathematically, you would like it.
Okay, cool. It's good to know that. Hey, do you want to?
Your company, will it be a law firm itself? I mean, will it be registered with the bar?
Is Uber a taxi company? So we have lawyers on the team, and there are structures now where non-lawyers can own and invest in law firms. So if it becomes convenient for us to, we've already talked to a law firm insurer who have said they're willing to insure us, even though we're not a law firm. So I don't know what that means. Yeah.
A contract takes place in a legal framework of a jurisdiction. Wouldn't your vision imply that you need to recodify the whole legislature to implement it into the contract, like a library?
Mm-hmm. Yeah, exactly. But that's a one-time cost.
Yeah.
Yeah. So once we do that, once we convert all the legislation into code, then the jurisdiction is just one line at the top. You can say import, right, Netherlands. And then you, if you want to change it, you just change the import line. Yeah.
have you checked legislation for errors or ambiguities or so? I mean, what if the legislation is flawed? Or,
Yeah, we could sell the product to governments too. So Singapore actually might pay us to start doing that. Yeah. Well, so Parliament would just be programmers. So Parliament would be programmers. Now, I come from the only country in the world where the Prime Minister and the Deputy Prime Minister are both computer scientists. So not many people know this, but Singapore is run by computer scientists. And we might do a contract with the Singapore government to start translating Singapore legislation into code. And Singapore would be like, oh yeah, we're the first country to do this. Right? It's like either us or Estonia. Yeah, behind. Yeah, go ahead.
So would you see yourself as a legal content provider?
I think we would create a structure where other people could start contributing, because it's an open source thing. So the first few translations from we would do, and then the rest we would start looking to law students and lawyers to start providing that content until you get this big GitHub library. Yeah, you wanted to?
Is a bit related to the question that you asked. So you would see that sometime down the future would be possible actually to not only codify contracts, but actually legislation.
Mm-hmm.
That whenever a new piece of law is drafted, that you could immediately check what are the scenarios and whether it's compatible or not with past legislation.
Yeah, yeah.
Mentioning that I spent a few years now in Tunisia, they adopted a new constitution, and they had a team of lawyers looking at past legislation whether it's compatible with the new constitution. Huge mess,
Yep.
as the past legislation was not very coherent
Right.
with a new constitution. So having such a tool would actually be a great,
Yeah. Yeah.
great thing.
And programmers have tools to do exactly this kind of thing in our world, right? We can say, we want to move this huge code base that's written in COBOL or Fortran, we want to automatically translate it into Java or C++. And there are tools that allow you to do that. There are tools that allow you to prove that you have done it correctly, right? And it's a kind of a similar kind of idea, right? So I think we're out of time. Should we move on, or is it lunch, or it's 4 o'clock in LA for some reason? Who's the next speaker? Do you want to get set up? And okay. Okay.
Thank you, Meng.
All right, you're welcome.